Good morning to all of you. Recently, the Nagpur bench of Bombay High Court, Justice Pushpa V. Ganidawale, she's a lady, she has given a judgment while dealing with an appeal in the case of Sathish versus State of Maharashtra in Criminal Appeal number 161 by 2020 on 19/1/2021, holding that groping a minor without skin-to-skin contact is not sexual assault as per Pocso Act, but an offence under section 354 of the Indian Penal Code. Of course, much outrage was caused, and people, even the scholars, they are telling that it is a senseless or insensitive or perverse judgment. So, if you go through the judgment, then it is you who have to decide whether there is any perversity or not. But of course, as a person, as an advocate also, I am also not satisfied with the interpretation of the judge. But as jurisprudence students, please know, it is the rule of criminal jurisprudence that the ratio or the proportion, so the conviction should be proportional to the offense. That means for a simple case of 324, you cannot punish a person for 10 years. They should have that ratio and proportion. We'll discuss all these things in the later course. Now, let us know the details of this case first. Right. So, here it happened on 14/12/2016, very 4 years back case. So, this accused person, under the guise of giving a guva in Telugu Jamkai, guva, he called the victim, who is a minor aged about 12 years, to his house, that is the upper portion of the house of the victim. Called her to the house. There he offered the guava. At the same time, he wanted to disrobe her, or he wanted to remove her salwar, and he touched her breast portion. This is the usual story you may be knowing. So immediately she started crying. That boy came down, and the mother, hearing her cries, she went there, and this innocent girl, she narrated the incident. Then they took him to Nagpur police station, where an FIR was registered against him. Simply to say, so he actually touched or tried to press her breast and tried to disrobe her or remove her clothes. A case under section 363, kidnap. So 341, wrongful restraint, then 354 IPC, and section 8 of the Pocso Act also was registered against him. The charge sheet was also filed. You may be knowing 354. So 354 means any act or assault or criminal force on a woman with intent to outrage her modesty. This is more important. The criminal intention should be there, outraging of modesty. So you may be knowing at the outset, 354, it was punishable for 2 years as per IPC. AP has given an amendment, I think it is in 2005, I believe, 1991. They have amended it to 5 years. Once again, after Nirbhaya Act came, the punishment was also once again lessened. So this is another story. So as far as now, they have booked both under 354 as well as Pocso Act. The trial court convinced with the version because it has examined 5 witnesses, after whom mother of the victim and victim, neighborhood who heard the cries, and also 2 police officers, 5 witnesses. So the trial court gave a conviction of 5 years. So aggrieved by this, he approached the High Court of Nagpur bench. Now, once again, the matter has come up for trial. So definitely, the judge has gone through the record, and she stated that the court observed that, the complainant could not prove that she was disrobed or she was about to be disrobed. There is a little bit confusion. So she could not say whether that fellow tried to disrobe her. She could not say whether he disrobed her. Nothing has come to light. So in such a case, right here, please remember, now it is not the case of prosecution that the accused disrobed her top and pressed her breast. Only thing is, so he pressed her breast. Of course, there is no skin to skin contact. This is the major problem in this case, right? So now, as per the evidence available, so for assault, for sexual assault under section 7 of the so-called Pocso Act, Prevention of Children from Sexual Offences Act, stricter proof is necessary. Right? Serious allegations are there, but for that, the stricter proof is necessary. Now let us know what is section 7 of the Pocso Act. So, whoever with sexual intent, this is more important, whoever with sexual intent touches, of course, the vagina, penis and breast of a child. So, with sexual intent, already I told you, which involves physical contact without penetration. Physical contact. So that means there should be some physical contact of that particular person. So the hand should have physical contact with the breast portion. It is not there. Therefore, section 7 of the Pocso Act will not come. Section 7 is the definition, 8 is the penal section. Now, it is an offence under section 354 IPC. Already I told you, whoever assaults or uses criminal force with intent to outrage or knowingly that the act will outrage the modesty, he will be punished. So this is nothing but 354 IPC. So the judge has stated that it will not come under section 7 of the Pocso Act. So therefore, she gave punishment. Of course, the section under section 354, the penalty was for 1 year. Right? So please remember, the basic principle of criminal jurisprudence is that the punishment for an offence shall be proportionate to the seriousness of the crime. So no doubt, the case in crime number 406 by 2016 was registered under section 354 and also section 8 of the Pocso Act, but they are not proportionate. Therefore, so she has lessened the punishment for 1 year. So this, but people are calling it as please remember here, I told you, you have to go to the golden rule of interpretation. So while deciding this case, the judge should have gone to the golden rule, that is the intention of the makers of the legislation. Why Pocso Act has been introduced in 2012? To see that the children are not subjected to sexual assault. Here intention is there, only the physical contact is not there. So the interpretation, so many people believe that it's the wrong interpretation by the High Court. Even please remember section 13 and 29 and 30 of the Pocso Act, they give definitely as just like our burden of proof. Here it says the court should presume that the offence was committed. But of course, now the only alternative is the parliament should clarify. They should give a judgment, it will be sufficient. But anyway, this case has given so much of publicity in the legal fraternity, and many people, majority of them are commenting adversely on the judgment. But anyway, as jurisprudence students, you have to know what is jurisprudence. So the ratio and proportion of the penals, and also the physical contact in section 7 of the Pocso Act. And of course, please read section 354 IPC, and definitely you will be enriched with the knowledge. But this is almost, I think, definitely Rekha Karla. She is a member of the National Commission for Women. Jyoti Karla, yes, already she has stated that she would approach the Supreme Court in this connection. Of course, if the Supreme Court goes away with this judgment, it's okay. But anyway, it's a judgment. I cannot say it's a good judgment, but a judgment, please read it, which has become controversial. That too, since she is a woman, we cannot do anything. If he is a male, then definitely. Even she is a woman, people are commenting. Suppose if somebody does the same act, then will she agree? All this, of course, these comments are there. But anyway, the judgment, please read the judgment and enrich your legal knowledge. Thank you very much.